Good morning. This is John Callis, President and CEO of Castle Breckenridge Management. Welcome to our June 5th Facebook Live show. Today we're privileged and honored to have a very special guest, the leading expert in mobile home park communities in the state of California, fondly known to me as the Queen of Mobile Home Parks, Miss Sue Loftin, the senior partner and owner and principal of the Loftin firm in Carlsbad, California, who will speak today on the ownership structure and applicable laws for mobile home park communities. Let's give her a big round of applause. Sue Loftin, it's all yours.
Good morning. It is a privilege and honor to be here. The ownership structures come generally in three types. You have the rental mobile home parks or investor-owned parks where they own the mobile home park and they rent the space to the person who owns the mobile home. Then you have the third-party nonprofit ownership structure. Just to highlight that for a moment, there's a lot of misunderstanding about those entities. They come in and say that they're a nonprofit, they're going to buy the park, it's going to benefit you, the resident, and if you just give them a $200 or $150 or a $300 rent increase, that will stabilize everything. Nonprofit does not mean that they can't raise the rents. They can, and they do. In some instances, they say that in 30 years you'll be able to own the park. That's also not true. So my caution to you is that if one of these groups come in, question them, make sure you understand fully what they're going to do, and don't be misled by their name. There are several in this category. Millennium and Caritas are two. They both are nonprofits. They handle very different types of parks, and this type of ownership sometimes is very beneficial to low-income parks. The third group is called resident-owned parks. The name is somewhat misleading because you will not own the park. Now turning to the third group, which is the truly resident-owned parks, we're going to talk about the ownership structure and applicable laws. The reason I chose this subject is over the 37 years of representing residents, park owners, and resident-owned parks, there's a lot of confusion over what they are. Mm-hmm. And everybody thinks that they're one thing. If you turn to the outline that I have, it looks a little overwhelming, I know. But this is a cheat sheet that I use and for my people in the office, and we have it online for people. If you go to the middle column, it talks about 4 general types of resident-owned parks. Common interest subdivision parks. These are parks where there's a lot of misunderstanding because stock co-ops are also a standard subdivision. And the name is misleading to people. And they say it's a co-op, so it's a co-op. There are very different types of co-ops. The standard co-op, which is the next column, is a membership type co-op where you do not have stock ownership and the laws are different. I'll get into that in a minute. The third type is a limited equity housing co-op. This is where the residents set up their own 501c3 to buy the park. And this is probably the least understood type of ownership. It provides it has some very beneficial financing opportunities with the 501c3. In addition, you can take tax deductible donations, you can get grants, you can approach corporations. We had one park wanted to set up a study hall for the kids, and they got all of their equipment, all of their computer equipment donated because they were a 501c3. None of the other types of ownerships can you give a tax deduction for a donation. The fourth type is a corporate ownership. That's where the residents simply form a corporation and they buy the park. The laws that apply to each of these is very different. Some laws apply to 1, some laws apply to 3, some laws apply to 2. I'm going to go through a very brief explanation and talk about the benefits of each. The DavisStirling Act, if you go to the top line, this is an act that applies to all homeowners associations, whether you're a mobile home park or a apartment building that's formed a co-op, or stick-built condominiums, or a single-family homeowners association. It has very rigorous requirements. The legislature amends it annually, as they do most of these type of laws. But the benefit to it is primarily to the members. What it does is it sets forth very specifically the duties of the board, what has to be and how you handle financial statements, what is distributed to the residents, what kind of disclosures you have to have, what kind of meetings you can have, and most importantly, how you can enforce your rules and regulations and your other restrictions on the property. So although a lot of people don't like it because of that, I personally think in looking at the mobile home parks, it's critical to have those protections. The DavisStirling Act applies to the common interest subdivision category, applies to the standard co-op, and it applies to the limited housing equity co-op, or the 501c3s. But those aren't the only laws that apply as we get to it. The next category, big category, is the nonprofit mutual benefit corporate law. And that's the law under which you form your homeowners association. And it is an important law because it augments what's in the DavisStirling Act as to what you can and can't do with your corporation. For example, if you as a group have collectively decided to have an election to do away with your current board of directors or a single board of director, that law is in the nonprofit mutual benefit. This is also the law that applies to homeowners associations, without regard to what type of homeowners association it is. The DavisStirling Act and some of the other acts that I'm going to talk about in a moment also impact what type of documents you need to have for your nonprofit mutual benefit homeowners association. It also applies to the corporate ownership. And this is important because if you note, the DavisStirling Act does not apply to corporate ownership. And that's an important distinction that I'll get into in a moment. The nonprofit public benefit, those are corporations that are formed that have a benefit to the general public. In the 501c3 housing limited equity co-op, the benefit is that you are providing a type of affordable housing. There are limitations in the IRS codes which apply to these as to how many low-income people, how many moderate-income people, and how many other income people you can have within these types of mobile home parks. When they're formed, you don't have to adhere to that because you can't evict anybody. But as the homes sell over time, the anticipation is that you will mature into that. The other common denominator in most of these is that there is a regulatory agreement filed by whomever does the financing, and that will require additional reporting. The nonprofit mutual benefit, by contrast, that's a nonprofit that is formed to benefit only the people that live within that community. You can have other nonprofits. For example, we have nonprofit recreational groups, football, and so on. And there's a lot of them, a lot of nonprofits that can fall. As we go through, then when you're doing the formation, the common interest subdivisions include, and including the stock cooperatives, you have to go through and get through your local jurisdiction to get your map approved. You have to get your permit through the local jurisdiction. And this is becoming more challenging because local jurisdictions are counting mobile home parks as low-income rental without regard to what they're paying in their housing plans. That is also illegal, by the way, to do that, but they do it anyway, so that they just gloss over and do their reports. But so some jurisdictions give you really a hard time. Those are primarily in Northern California, not Central or Southern. The other thing that you have to first get your permits from the local jurisdiction to subdivide, and then you have to go to the Department of Business oversights into two different sub-agencies, what we all used to call the Department of Real Estate, and I still call it that, but it's technically the the BRE now, and get a public report. What that is the Department of Real Estate goes over your documents, determines that you comply with the Subdivided Lands Act, the Department of Corporations, the DavisStirling Act, and so on. It is a check-the-box type of organization. And then you get your permit to sell. And at the same time, you have gone through the Department of Corporations to have all of your corporate documents approved. The standard co-op is a little different. You don't have to go through all of the agencies that I just mentioned. But do have to go through what used to be the Department of Corporations in order to get a permit to sell the memberships. It is not a stock, it is a membership. And the language is critically important because it makes a big difference on who's going to do the overseeing. Any entity that has to have a securities permit from the Department of Corporation, it is also required that each time a home and membership is sold, you have to send in for approval for the Department of Corporations. That sounds horrible, but it's a 2-page document that's handled through escrow. The limited equity housing co-op has a lot more to go through. You have to go through the Department of Corporations, you have to go through the IRS to get your designation, and you have to go through the state additionally to get your permit. The one type of ownership that we don't generally use is the straight corporate ownership. We only use that with a resident group who is going to buy the park, hold it, and then they're going to be the subdivider. We don't use it to hold long-term. And the reason is that the mobile home residency law still applies. And we've been called into a number of parks where the board of directors, who has all of the same powers as a single owner of a rental mobile home park, is terrorizing the residents, the same as many of the owners that they wanted to get rid of. So we when we get called in, we reform them as a standard co-op so they're protected. But that's the limited use of that. There's a lot of other laws that apply, and I don't have time this morning to go through all of them. Just to touch on a couple. Yes, Title 25 applies no matter how you own the park. Other types of laws apply. My least favorite, the Coastal Act, which the Coastal Commission administers, and you need to be aware of that. And with that, John, I'd like to turn it back to you and see if you'd like me to fill in anything or if anybody has questions.
Well, I have a question that comes to my mind in working with you over the last 20 years. One of the most vexing issues I've noticed for homeowners and boards of directors at the mobile home parks is funding for their parks if they bought the park. Could you very briefly talk about the options available to homeowners who are looking at either financing or refinancing?
Okay, is it financing or refinancing the mobile home park or the homes?
The park.
We work with a number of different lenders, and the key to it that I have found is that you go in with your full package up front, and then you shop it. You also go in with a history of defaults on loans by residents who own the park. And to my knowledge, other than a group that did corporate ownership only, but then it was a scam to get the money for them, there's only been one park that went into foreclosure, and that was a corporate ownership park. And that's been 15, 20 years ago. But it is more challenging than other types of parks to refinance. And the key that the residents have to understand is they need to have their books in order, their financial books in order. They need to have less than 5% delinquency over a period generally of a year. They need to have updated documents. And this is an area where we have found we've gone into parks and the documents haven't been updated for 15, 20 years. They're not going to loan on that. The other thing is allowing residents to explain what kind of ownership they have. When we've run into issues on it, it's been, well, they told me it was this, and we go, well, no, it wasn't that, it's this. And when you start into that, then they have issues. The other critical point is you need to have an experienced management company, because the lenders will look at that, and that management company needs to have been in place before you may apply for the loan.
Is there any state underwriting for loans at this moment for mobile home park communities?
Yes, and they've expanded the purpose of these state funds so that you can go in and apply for rehab loans. There's still funds available for low income for parks that are being purchased.
Uh-huh. Is MPROP still available through the state of California?
IMPROP is the historical program that was started in 1985 and passed by Senator Craven, so that the goal of IMPROP is no matter what your income level, if your park is going to be converted, you can participate and buy in. And that is still available, and they changed the name this year, and I can't remember ever what it is. It's something like the Mobile Home Park Resident Lending and Rehabilitation Housing Fund, and but after calling it IMPROP since 1985, I just have a mental block.
Do we have any other questions from the audience?
Yeah.
If you end up in a residential mobile home park, how do you find out what kind you're in?
You need to look at the documents that you're given. And for the DavisStirling parks, you should receive all of the operating documents. You should receive the financials. You can request 12 months of minutes. And from that, you should be able to find out. And it is important for someone who's looking to buy into a resident-owned park to make sure that you know what it is. And keep in mind, there's one group of nonprofits that call themselves resident-owned, but they're not. And so that does become an issue.
Other questions? Brian?
May have already answered this partially, but this is from a property that we manage. It says, we are operating under our original documents, and our documents have not been amended in years. Do we need to amend our documents, and if so, why?
Okay, yes, absolutely you need to amend your documents. And the reason why is that the legislature has substantially changed the laws over time. And to go back to the first question, people read the documents to determine what they have to do. That's incredibly misleading in your example, because the law supersedes whatever you have written. And how are the residents going to know what they are supposed to do if you have not updated your legal documents?
Other questions? Yes, Therese?
Yes, does the mobile home residency law apply to resident-owned parks?
The question is, does the mobile home residency law apply to resident-owned mobile home parks? I can give you a great legal answer to that, yes and no. The mobile home residency law has different pieces to it. For any resident who lived in the park at the time it was purchased by the residents and elected not to participate, what everybody thinks about is the mobile home residency law. Civil Code 798 applies. 798 also applies in the corporate ownership, which is why we don't use it as a permanent ownership structure. There is also a section in the mobile home residency law that applies to the common interest subdivisions, the standard co-ops, and the limited equity housing co-ops, and that's 799, and that does apply.
Any other questions? Yes.
Could you confirm if a corporate ownership is or is not a cooperative?
The way that you confirm it is by you look at the documents. If there's only documents that have where you have a articles of corporation and you have bylaws, you're a straight corporate ownership. If you have other documents such as recorded CC&Rs and so on, then you're a standard co-op. If you are selling stocks, then you are a stock co-op.
Yes, Deborah?
Yes, thank you, John. Sue, we don't own our park yet. So how do we best decide which type of ownership would be appropriate and the best for us?
Oh, that's an excellent question, and one that a lot of resident groups will get sold on a particular type of ownership. And that happened in San Diego County with the corporate ownership. It was greatly abused. John has represented some of the parks in management. I've represented them in redoing their ownership structure and in litigation against this group. So you need to hire somebody to do a feasibility study. You need to look at where your location is. Are you in the coastal area? Then if you're in the coastal area, although we've done numerous subdivisions in coastal over the last 5 years, and where they are today, where they're trying to get legislation passed where no residence built after 1977 can be protected by a seawall or in any other manner. We are not looking at doing that until some of these power grab issues are resolved. And so a lot of it depends on location. You need to do a survey of your residents so you find out where their income levels are, because that will make a difference in where you go. Age of the homes, financing will depend on some of those factors. So it is an important study to do, and then invite people in who, there are people who do only one of these things. Our firm does all of them, but we encourage any group that wants to hire us to interview other people because it is a long-term, gut-wrenching, confusing event to buy your park, and you need to trust the people that you hire.
Okay, one last question, then we'll have to close. If a owner group is looking for a competent and seasoned management company to manage their mobile home park community, what are the key prerequisites they need to be looking for?
Experience with mobile home parks and resident-owned mobile home parks. We have parks that have gone through, no matter who we recommend, which we recommend Castle Breckenridge to all the parks, but somebody's nephew owns this and they want to be able to walk down the street or whatever the reasons. And when you get into like a common interest, you have the DavisStirling Act, you have the Corporations Act, you have the 799 of the Mobile Home Residency Law, you have the Mobile Home Park and Manufactured Housing Acts. You have certain things that you can and cannot do in mobile home parks. And so experience is critical. The other piece to it is understanding experience in how you operate the park, and special focus on how the financial aspects are handled. We're dealing with a park right now that the CPA who's been handling their finances, I haven't strangled him yet, but I'm coming close to it, because he's never dealt with a mobile home park. And so those are a lot of the issues, but it is experience. And I would certainly recommend to any of you Castle Breckenridge.
Well, we've run out of time, unfortunately, but I do have to say once again, you've been very illuminating today about a very complicated issue, which is the management and the legal representation for mobile home park communities. Let's give her a big hand.